with
All right.
a felony.
All right. Well, anyways, this was supposed to be a recommendation for the prosecutor, and it isn't necessarily a sentencing agreement, but apparently that's not what you request. Is that correct? You can change your mind between now and sentencing, I guess, if you choose.
Yeah.
All right.
Yeah.
All right.
Yes, sir. I'm sorry.
It's okay.
I'm kind of confused with everything that you
Well,
said. So
that's why you've got Mr. Champion there. He will unconfuse you.
This next guy is pleading guilty to drunk driving, but here's the thing, this isn't his first time or his second. Watch how casually the judge walks through this, like it's just paperwork right up until the blood alcohol number comes out.
Mostly.
Or make it worse.
No, you'll do fine. All right. So far, Mr. Denhoughton, did I get the plea agreement right?
You did your,
Mr. Champion, other than that little hiccup?
that is the correct statement. I'm thinking right now.
So, Mr. McKenzie, now I have here this pre-trial agreement. I'm going to hold it up for you. And it's 2 pages long. The terms really appear only on page 1. And on the back, on page 2, is some signatures. I'm looking right here. Is that your signature?
yes, sir.
Okay, well, you should shrugged your shoulder. Did you sign a piece of paper?
I did this
Okay.
morning. Yes, sir. I did.
Good. Now, before you place your signature on there, did you have the opportunity to go over and speak with, the evidence, your rights, your
Yes.
choices with Mr. Champion?
Yes, I did.
And he made himself available to you?
Yes.
Did he answer all your questions in a way that you understood them?
Yes,
All right, good. And so therefore, are you satisfied with his advice at this time?
I am.
All right, good. Now, also, if you enter this plea today, as I described, and I accept that plea, you'll be waiving certain rights and not have a trial. Does that make sense?
Yes, sir.
All right. So the second piece of paper I'm holding up is one that says advice of rights. And again, it looks like your signature. Is that your signature on this document?
Yes, sir. It is.
Now, before you placed your signature on there, did you read through all these terms and conditions?
Yes, sir. I did.
And this one, I don't mean to sound insulting. Did you understand all of that? The words?
Yes, sir.
Okay. So you understand that you are waiving all these rights that are listed on this page?
Yes, sir. I do.
All right. Thank you very much. Also, you're going to be giving up the right to claim later on that this plea was a result of some promise, threat, or inducement not told to me today. So, before I get ready to take the plea, have there been any other promises, threats, inducements, coercion to force you to plead guilty?
No, sir.
Are you doing so then?
I-
Hold on. You're jumping my gun, man. I get paid in my words. Just take a moment. Are you making this plea of your own free choice?
Yes, sir.
Great, thank you. Now, there's this thing on page 1 of that pretrial agreement. It talks about sentencing, and it has this thing called the Michigan Sentencing Guidelines. Now, those guidelines are used for felony cases and felony convictions, and they are given to the courts by the legislature. Now, we are not required to follow them. We take them and we are required to consider them, but we don't need to follow them. And what they do is they establish the minimum end of a sentence. So I told you, for instance, this as it's a felony punishable by up to 5 years. Now, the attorneys appear to think that they estimate the guidelines would suggest a sentence of 0 to 3 months. All right. Now, I want to highlight for you, that's not binding on me. Next, it says the word estimated, which means they could be right, they could be wrong. Do you understand?
Yes.
Good job. All right. Thank you. Has anyone made any promises to you or asserted, hey, this is exactly what Judge Elmore is going to do for sentencing?
No, sir.
Good. I don't know. All right. But I'm going to guess the priors must be quite old. Yeah. All right.
10 years.
Well, anyways, knowing all that, Mr. McKenzie, do you still wish to enter this plea of guilty that we talked about today?
It is, sir.
All right. Thank you. As to count 1, operating a vehicle while intoxicated, how do you plead?
Guilty, yours, sir.
So I'm going to ask you some questions. I've got to be able to make sure that you actually believe you are guilty. So turning your attention to April 17th of this year, over in Lake Township in Missaukee County, were you operating a vehicle on a public roadway?
I was.
Looks like it was somewhere either on, looks like it was on West Jennings Road near South Blythe. Is that right?
Yes, sir.
And at that time, did you get pulled over by a police officer?
I did, sir.
And had you been consuming alcohol?
I had.
And Mr. Denhout, Do we have an toxilizer or breath?
It was a lab report.
Go ahead.
It was a lab report, Your Honor. The results were 0.228 blood alcohol content.
Mr. Champion, does the defense so stipulate?
We do, Your Honor.
All right, thank you. Now, Mr. McKenzie, is it also true that
A 0.228 blood alcohol level that's almost 3 times the legal limit. And remember, this is strike 3, 1997, 2016, and now this one. The judge doesn't even blink. This is just Tuesday in this courtroom.
December 12th, 1997, in the 84th District Court, which I presume was either here or over in Wexford, you were convicted of operating while intoxicated? Is that right? Did you have a prior conviction in 1997?
Yes, sir.
Okay. Sure?
Yeah.
All right. And is it also true that you had another operating while intoxicated conviction on May 2nd of 2016? And that looks like it was also either in this court or this court over in Wexford County.
Yes, sir.
All right. Thank you. Mr. Denhon, do you believe the defendant provided a factual basis to support the plea?
Yes, sir.
Are you aware of any other promises, threats, or inducements?
No, Your Honor.
Do you believe the court's compliance with Rule 6.302?
Yes, sir.
Mr. Champion, do you agree with all that?
I do, Your Honor.
Thank you. The court agrees and finds the defendant's plea today is made freely, knowingly, and voluntarily. The court further finds the testimony provided by the defendant under oath on the record satisfies the required elements for proof. Therefore, the defendant is found guilty of count 1. Count 2 and 3 will be dismissed at the time of sentencing. Sentencings, Mr. McKenzie, are generally done in about a month after taking the plea. Sometimes it can be up to 5 weeks. Between now and then, an agent from the Michigan Department of Corrections must prepare a pre-sentence investigation report. This report is prepared anytime someone is convicted of a felony in a state court in Michigan. That report will come to the judge and come to the attorneys, and it will tell us here's what the charges were, here's what the plea was, information about the defendant's prior criminal history, performances on bond, performance on probation, other facts about that you're going to provide an answer, like about work history, things like that. It will also include a scoring of the Michigan sentencing guidelines. And I talked to you about that earlier when I pointed to on that pretrial agreement on page 1. Again, the guidelines are not mandatory, but they are an important tool for the courts to consider. Next, it will also make a recommendation as to sentencing. That is merely a recommendation. It's strictly up to me. All right. Now, there are 3 steps that involve you, sir, in the preparation of this report. Number 1, when you leave this courtroom, that person over there is going to give you a packet and going to schedule an interview with you. You're going to fill out that packet, turn it back in, and they will schedule an interview with you, for you with one of their agents. Then that agent will prepare the report, and when it's done, which is generally about 2 weeks or 10 days prior to sentencing, the attorneys will get it, I'll get it, and Mr. Champion will have to sit down and go over it with you to make sure that whether or not there needs to be any corrections. Sometimes they might get information incorrect, so we need to make sure that it's complete and accurate before the court uses it to help establish a sentence. Do you understand today, Mr. McKenzie?
Yes, sir.
Do you have any questions about this process for me at all?
No, sir.
Okay, good. Now, you must have some bond conditions, right? Are you doing breath tests? Or,
Yeah, I have a,
Yep, soberly?
yes, sir.
Good. So, and did you go to community corrections? Because we don't do those.
Yes, I do, sir.
Great. Good. Good. Well, make sure you can continue to be compliant with those terms or conditions. How you perform on your bond is a big issue for this court. It tells me whether or not, probation is going to work or probation may not work. All right. And you probably want it to work.
He's doing well, Your Honor.
I'm very happy. And if you need any other assistance, there's nothing wrong with going to that community corrections office and saying, you know what, I could use some outpatient therapy just to help me get through whatever. There's nothing wrong. That does not work against you. It works for you. All right. So if you think you need any outpatient treatment, you can either get it on your own or go to Alex at that office and she'll help get you into it. Okay.
And just like that, third DU won, done in under 10 minutes. If you want to see how these plea hearings actually work behind the scenes, hit follow. We've got a lot more of these real courtroom moments coming.
All right.
Okay, that's good to know. Thank you, sir.
No, you're welcome. Anything else, Mr. Denon?
I would just indicate that I'm not aware of any bond violations, so I have no objection to continuing bond, Your Honor.
Bond hereby continues. Anything else, Mr. Champion?
Your Honor, thank you.
All right, great. Thank you. We are
Here.
Thank you.
Everything here.
Mr. Smith, once you get to the podium, could you please state your name for the record?
Joshua Smith. Thank you.
Your Honor, today is the date and time set for a PCC in this matter. We would be asking for an adjournment of the PCC to complete discovery in this matter. I have gotten some initial discovery, but I believe there is more coming after speaking with Madam
Is this the only
Prosecutor.
thing holding him?
I'm sorry, Your Honor.
Is the only thing holding him?
Yes, it is, Your Honor. And we would like to address the matter of bond when the court is ready.
Cause conference, July 11th,
July 11th.
2024, 9 a.m. Or as your invite indicates.
Thank you, Your Honor. May I address the matter of bond, Judge?
You may.
Okay, so this guy's attorney is about to spend 3 straight minutes telling the judge what a great guy his client is. Clean record, steady job, tight-knit family. Sounds like a normal bond hearing, right? Stick around because in about a minute, you're going to find out what he actually did to a 14-year-old kid, and it's all on video.
Your Honor, Mr. Smith has no prior convictions other than possibly a driving while license suspension case. I did run his iChat and it was completely clean. He's been incarcerated for 9 days since June 18th. He has retained counsel and is serious about facing the matters in front of him. He's a 30-year-old man that lives in Ypsilanti and has an apartment he's prepared to go home to. He's a lifelong resident of the Metro Detroit area, growing up in Canton and graduating from Plymouth High School in 2013. He has extremely strong family support in this matter. His mom, dad, and sister all live in Canton, and his extended family out of the state has been calling to check in on Mr. Smith and help in any way they can. His mom is a assistant deputy director of field operations for the Michigan Department of Correction, essentially in charge of supervising parole and probation, or parolees and probationers. His dad is a retired worker from DTE Energy. His parents have borrowed from their retirement in order to retain counsel on his behalf. Speaking to Mr. Smith's work background, he's obviously resigned from his job due to this case, but he has been consistently employed since his senior year of high school, working in various industries like food service, manufacturing, trucking, and hospitality. He is confident that he can become employed should he be released in this matter, and he does believe he has a lead on a case or on a job to become a janitor. I have had a chance to review the police report in this matter, Judge, and I would note that there's no mention of any injury to the complaining witness or no mention of any medical treatment. And based on that police report, I've done a preliminary run of his sentencing guidelines, and assuming for the sake of this bond argument only, that if he were convicted of assault with intent to do great bodily harm and he were given points under OV3 for bodily injury requiring medical treatment, maximum points for psychological injury to the victim, and maximum points for exploitation of a vulnerable victim, his sentencing range would still be 0 to 17 months, meaning it would be an intermediate sanction since it's an under 18-month sanction. And as this court is well aware, jail is not an intermediate sanction. So that presumptively this would be a probation
I
sentence.
understand how
even if
sentencing
convicted.
works. Go ahead, get to your end of your argument.
Okay, concluding, Your Honor, I would note that there was 14 days between the arrest and the incident in this matter where there were no allegations of wrongdoing. Mr. Smith was proactive in looking out and getting a booked therapy appointment, which he would like to get back to. We'd be asking for a cash bond that Mr. Smith can afford because we do not believe he is a danger to the community or a flight risk. We'd ask for a $2,500 10% cash bond in this matter, Judge.
Response.
Your Honor, we originally requested a $75,000 cash as surety in this case, and we were given $75,000 with 10% privilege. This is a case that was completely captured on video. The defendant is a teacher at Ypsilanti High School. The victim in this case is a 14-year-old student. Here, the victim and the defendant appear to have gotten into a verbal argument. At one point, the defendant instructed the victim to do push-ups. The victim told the defendant that he was unable to do so because he had a wrist injury. And then at that point, the defendant got in the 14-year-old space and said, "That's some bitch ass shit." The defendant then followed the victim as he started to walk away. And at that point, he strangles him for several seconds with the sleeve of his sweatshirt. It was only when two teachers walked up and intervened that this concluded. The whole thing is on is on video. And aside from the physical acts of the defendant, what is extremely concerning is that in his own words, in his statement to law enforcement, when asked what happened, he said he had a headache and he snapped and he knew it wasn't right. So I'm significantly concerned based off of the nature of the physical acts, which were all caught on video, but also the defendant's own admissions here about what exactly happened.
May I have a brief rebuttal, Your Honor? Even with the
There was
serious,
a 14-year-old, he was a teacher, and there was a strangulation.
those are the allegations, Your Honor.
Yeah,
And
go ahead with your response.
even with the seriousness of these allegations, we fully recognize the seriousness. I think the guideline argument remains that this still is a presumptive probation. And I think to the danger of the community, I think the 14 days between between the incident and arrest where there was no court order in place, where there's no allegations of wrongdoing, speak to the danger of the community that Mr. Smith is. And I believe that that danger can be mitigated with reasonable terms of bonds, such as possibly a tether or a cash bond that he may afford, which we would ask for 2,500, 10%, Your Honor.
There's a 75,000, 10% bond.
I understand, Judge.
They didn't request that I raise it. I actually should raise it, given what I've heard. I will not. However, your motion for bond reduction is denied.
Your Honor, would you consider release if he was to live at his mother's house rather than by himself in Ypsilanti as a condition of bond?
And there it is, motion denied. No matter how many character letters or sentencing guideline numbers his lawyer threw out, the judge wasn't buying it. A teacher choking a student with his own sweatshirt sleeve, caught on camera, and then telling police, "I just snapped." That's not something a clean driving record fixes.
Did I thought I ordered something.
I was just asking if it would sway your decision at all, Your Honor.
No, when I'm done, I'm done.
Fair enough, Judge.
Thank you.
Thank you, Your Honor.